I'd like to go to the next speaker, and that's the Honourable Pamela Tate, AMKC. And she's an adjunct professor of law at Monash University and a former judge of the Court of Appeal at the Supreme Court of Victoria. When Solicitor General, she was special counsel to the committee that recommended the enactment in 2006 of Victoria's Charter of Human Rights and Responsibility. So there's a connection here. She is a director of the Australian Academy of Law, and in 2018, Monash University conferred upon her an honorary Doctor of Laws. She's a former patron of Women Barristers Association and the current patron of the Australasian Association of Philosophy and the Human Rights Law Association. So I'd like to welcome the Honourable Pamela Tate.
Well, thank you very much, Marc, for that warm introduction. Well, I want to address the topic of understanding human rights law in the coronial jurisdiction by taking a step back. The issue I want to address is, in a general sense, how and when did human rights law become relevant to coroners? In effect, I'm asking the question, how did we get here? Well, I want to answer that question by looking in some detail at the right to life. This right is the primary source of the relevance of human rights law to the work of the coroner. Now, Simon has touched on some of this already, but my aim is to take a deep dive into the scope of the right to life and to examine its implications for the coronial jurisdiction. I want to consider first the international law basis of the right to life. I also want to look at two comparative jurisdictions, namely the United Kingdom and New Zealand. In particular, I want to examine a recent New Zealand case, Wallace and the Attorney General, which has dealt with some novel questions that were previously unresolved. This takes us away from the strictures and constraints inherent in the Victorian Charter to a broader view of the relevance of human rights law in this context. Well, as many courts and commentators have observed, the right to life needs to be understood and domestic statutory provisions interpreted in the international context. The United Kingdom looks to the European Convention for the Protection of Human Rights and Fundamental Freedoms as its principal rights-protecting international instrument. Article 2 of the European Convention protects the right to life. It's included in the Convention rights that are given effect in domestic law by the enactment of the UK Human Rights Act 1998. So in the UK, there is no separate domestic statutory expression of the right to life. The UK Human Rights Act simply gives effect to Article 2 in the terms in which it's formulated in the European Convention. This differs from New Zealand, and for that matter Victoria, where the respective parliaments have adopted their own domestic formulations. And later I'll consider whether this difference has any significance. Article 2 of the European Convention relevantly provides, everyone's right to life shall be protected by law. No one shall be deprived of their life intentionally, save in the execution of a sentence of a court following their conviction of a crime for which this penalty is provided by law. Well, New Zealand relies upon the International Covenant of Civil and Political Rights, the ICCPR, as its principal international instrument for the protection of rights and freedoms, and we've heard discussion of that already today. New Zealand's commitment to the ICCPR is affirmed under domestic statute by the New Zealand Bill of Rights Act 1990, New Zealand BORA. The right to life is protected by Article 6 of the ICCPR. This relevantly provides, Every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of their life. Both Article 2 of the European Convention and Article 6 of the ICCPR recognise that the infliction of lethal force by an agent of the state may be justifiable, that is, may be lawful and not arbitrary, if necessary and proportionate, for example, in self-defence. Well, despite the differences in the language between Article 2 of the European Convention and Article 6 of the ICCPR, they are viewed as generally having the same effect, as they both aim to implement the Universal Declaration of Human Rights. This has led to cases from one jurisdiction being relied upon in the other. In particular, cases from the European Court of Human Rights or the UK Supreme Court are often relied on in New Zealand. When it came to the New Zealand Parliament's intention to affirm the rights under the ICCPR, it chose to modify the language of the right to life as formulated under the Covenant. Section 8 of New Zealand BORA, the statutory expression entitled life, provides, "No one shall be deprived of life except on such grounds as are established by law and are consistent with the principles of fundamental justice." Well, the principles of fundamental justice prohibit, in particular, arbitrariness or gross overreach. Well, of course, it's the ICCPR that also serves as the model for the rights protected under the Victorian Charter. The Victorian Parliament also modified the language so that Section 9 of the Charter, entitled Right to Life, reads, "Every person has the right to life and has the right not to be arbitrarily deprived of life." Well, neither Section 8 of the New Zealand BORA nor Section 9 of the Charter include the words that the right to life shall be protected by law, words found in both the European Convention and the ICCPR. The New Zealand Court of Appeal and Wallace and the Attorney General recently had to grapple with the question of whether the omission of those words, "shall be protected by law," has an impact upon how the right to life is to be interpreted and what obligations it gives rise to on behalf of the state. It had to answer the question whether the right under the New Zealand BORA is equivalent in scope to that under the ICCPR. Well, the primary means of identifying the scope of rights under the ICCPR is to look to the general comments made by a specialist body of independent experts for which the Covenant expressly provides, the UN Human Rights Committee, that monitors its implementation. In its most recent version of the general comment on Article 6 in 2019, the committee observed that the right to life is the supreme right. It has crucial importance both for individuals and for society as a whole. It is most precious for its own sake as a right that inheres in every human being, but it also constitutes a fundamental right, the effective protection of which is the prerequisite for the enjoyment of all other human rights. The scope and protections afforded by Article 6 are far-reaching. The UN Human Rights Committee said it lays the foundation for the obligation of states to respect and ensure the right to life, to give effect to it through legislative and other measures, and to provide effective remedies and reparations to all victims of violations of the right to life. The committee recognised that respect for the right to life involves a negative obligation of restraint on behalf of the state, a prohibition against the state engaging in the arbitrary deprivation of life. This responsibility extends beyond the actions of state actors who actually administer lethal force and includes any loss of life for which the state may be held accountable. As the committee observed, respect for the right to life entails the duty to refrain from engaging in conduct resulting in arbitrary deprivation of life. State parties must also ensure the right to life and exercise due diligence to protect the lives of individuals against deprivations caused by persons or entities who are not state agents. This extends to reasonably foreseeable threats and life-threatening situations that can result in loss of life. The general comment acknowledges the special duties the state has to people who are incarcerated or otherwise detained. A duty of care is recognised to take any necessary measures to protect the lives of individuals deprived of their liberty by the state, since by arresting, detaining, imprisoning or otherwise depriving individuals of their liberty, state parties assume the responsibility to care for their lives and bodily integrity. An example of this is the famous case of Amin and Secretary of State. There, the House of Lords held the state responsible for a breach of the right to life when a young person in custody was murdered by a cellmate with a history of violent and racist behaviour. Well, in addition to the duty to protect against deprivation of life and life-threatening risks, the right to life also gives rise to positive duties. Relevantly, there is an implied positive obligation under Article 6, the ICCPR, on behalf of the state to investigate certain deaths. This has been described as a right to a thorough investigation of deaths. This means that where a death occurs and the state is implicated as being responsible, there is a further requirement of an independent and thorough investigation. In Amin, Lord Bingham described the scope of the implied positive duty to investigate. He did this in a manner endorsed in 2025 by the UK Supreme Court in Inri Dalton. Lord Bingham explained that the essential purpose of a human rights compliant investigation is to ensure as possible that the full facts are brought to light, that culpable and discreditable conduct is exposed and brought to public notice, that suspicion of deliberate wrongdoing, if unjustified, is allayed, that dangerous practices and procedures are rectified, and that those who have lost their relative may at least have the satisfaction of knowing that lessons learned from their death may save the lives of others. In general, an investigation should involve a degree of heightened scrutiny and to extend to an examination of the surrounding circumstances. It may extend to circumstances where loss of life is an indirect consequence of a state action, for example, through the manner in which a police operation is planned and controlled. As the European Court of Human Rights said in McCann in the United Kingdom, deprivations of life must be subject to the most careful scrutiny, particularly where deliberate lethal force is used, taking into consideration not only the actions of the agents of the state who actually administer the force, but also all the surrounding circumstances, including such matters as the planning and control of the action under consideration. Well, the investigations required by the right to life may take various forms, including criminal prosecutions and coronial investigations and inquests. Relevantly for the coronial jurisdiction, General Comment 6 goes on to describe the importance of the investigation, identifying the deceased and arriving at the truth of how the events led to the death. It says, where relevant, the investigation should include an autopsy of the victim's body, whenever possible, in the presence of a representative of the victim's relatives. State parties need to take, among other things, appropriate measures to establish the truth relating to the events leading to the deprivation of life and identify the bodies of the individuals who have lost their lives. State parties should also disclose relevant details about the investigation to the victim's next of kin, allow the next of kin to present new evidence, afford the next of kin standing in the investigation, and make public information about the investigative steps taken and the findings, conclusions, and recommendations emanating from the investigation. The recommendations are to assist, as Simon mentioned, by identifying steps to prevent the occurrence of similar violations in the future. Well, we can now pause for a moment to reflect with some precision on how the right to life, as protected at the level of international law and affirmed in domestic law in the United Kingdom and in New Zealand, how that is relevant to the work coroners undertake. It's clear from the material canvassed that the coronial jurisdiction may be an important means by which the state carries out its positive investigative duty, implied under the right to life, to thoroughly investigate deaths in which the state is implicated or for which the state should be held accountable. That is, coronial investigations and inquests may be a means by which the state discharges its obligation to protect the right to life. Crucially, this imposes human rights standards which coronial investigations must meet in order to discharge that obligation. So human rights law is relevant because if the work of the coroner is to discharge the investigative obligation implied by the right to life, it must meet human rights standards. The international case law indicates that an inquest will often be the most apt and rights-compliant investigative form where the state is implicated in a death. However, whether in a particular case a coronial inquest meets the requirements of Article 6 of the ICCPR will depend upon how it is conducted. This will depend upon the facts of the case and the course of events at the inquest itself. Well, turning then to the case of Wallace and Attorney General. This case is a good illustration of the close inspection a court will engage in to determine whether a coronial investigation meets human rights standards, the requirements of Article 6. Heard in 2021, this was the first case to consider the nature and extent of the Crown's obligations under Section 8, the right to life, in the New Zealand Bora. The case arose because a police officer in New Zealand shot dead a 23-year-old man, Stephen Wallace. In the early hours of one morning, Wallace went on a violent rampage through a small rural town. He used a baseball bat and a golf club to smash the windows of the police station. He also smashed a police car driver's side window and windscreen, as well as shop windows. He threatened bystanders, including by smashing the driver's window of a passing taxi. Two armed police officers approached and attempted to reason with him. One of them yelled, "Armed police, drop your weapons." Wallace did not back down. Rather, he advanced on one of them, Constable Abbott. Abbott was forced to retreat, moving backwards. Wallace yelled, "You've pushed me too far," and that he was going to kill Constable Abbott. He held on to the baseball bat and threw the golf club at Abbott. Abbott fired a warning shot in the air. Wallace continued to advance. Abbott shot him dead. Numerous investigations followed. They included a police investigation, a depositions hearing, and a criminal trial brought as a private prosecution by the family against Constable Abbott after the Crown decided not to prosecute him. The private prosecution resulted in an acquittal on the ground of self-defence. In addition, there was a coronial inquest and an investigation by the Independent Police Conduct Authority. When all these inquiries had been completed, Wallace's mother brought civil proceedings against the Crown in New Zealand's trial court, the High Court, claiming that the events of that night breached Stephen Wallace's right to life under Section 8 of the New Zealand Bora. She alleged that none of the investigations undertaken were adequate to give effect to the right, and nor were they adequate when considered cumulatively. It was accepted that the core of the right to life was engaged because Wallace was killed by an agent of the state. However, the trial judge, Justice Ellis, noted that Section 8 of the New Zealand Bora had not generated jurisprudence proportionate to its importance, and that many of the questions raised were novel, at least in a domestic context. One of those novel questions, and this is what I flagged earlier, was whether Section 8, the statutory domestic expression of the right to life protected under the ICCPR, generated an implied positive duty to investigate a death in which the state was implicated. It was accepted that, as we've explored, in international law, the right to life gives rise to an implied positive investigative duty. However, the question for the court was whether the right, as expressed in the New Zealand Bora, impliedly generates the same duty. The question was crucial to the viability of the proceeding, and it required a determination before any assessment of the facts or potential liability of the state. The question arose because of the drafting differences I mentioned earlier between the right in the international instruments and the expression of that right in domestic law. Crucially, as I highlighted before, Section 8 of the New Zealand Bora does not include the words that the right to life shall be protected by law, words that appear in both Article 6 of the ICCPR and Article 2 of the European Convention. The argument in Wallace was that it was those particular words, shall be protected by law, that established the basis for the implied obligation to investigate, and in their absence, no such positive investigative duty is to be implied. Well, the New Zealand Attorney General submitted that there were a number of statutory mechanisms in New Zealand aimed at ensuring that the relevant investigation would occur. In those circumstances, it was argued, there was no justification in recognising a further implied positive obligation to investigate derived from human rights legislation. Justice Ellis dealt with this important question first by querying how the right to life in the New Zealand Bora would be vindicated if the available statutory processes proved inadequate in any particular case by reference to human rights standards. She also accepted that while the duty to investigate may be linked to the duty under law to protect life, it is also linked to the obligation not to take life unlawfully. That is, the right every person has not to be deprived of their life. She focused upon the purpose of Section 8 and said that to achieve the purpose of protecting life, it makes sense for a protective obligation to arise regardless of the way in which the right to life is expressed. For this proposition, she relied on observations made by Baroness Hale in Savage and South Essex NHS Trust that one of the duties arising from the right to life is an implied positive duty properly and openly to investigate deaths for which the state might bear some responsibility. This is because, Lady Hale said, there is not much point in prohibiting police and prison officers, for example, from taking life if there is no independent investigation of how a person in their charge came by her death. In other words, the prohibition on taking life will have little effect unless there is the threat of an independent investigation when a life is taken. Justice Ellis concluded that the reasoning of Lady Hale's applies with equal force and logic to Section 8 of the New Zealand Bora. She went on to focus upon the purpose of Section 8 and why it's necessary to interpret that section in accordance with its purpose. She said, the prohibition on depriving others of life is toothless without a parallel obligation to interrogate and test the circumstances in which such a deprivation has occurred in the individual case. As with Article 2, the interpretation of Section 8 must be guided by the fact that the object and purpose of the Convention as an instrument for the protection of individual human beings requires its provisions to be interpreted and applied that makes its safeguards practical and effective. She continued, in my view, therefore, a purposive interpretive approach to Section 8 not only permits but requires the inclusion of an obligation to investigate a death that has occurred at the hands of a state actor. Well, the New Zealand Court of Appeal agreed with Justice Ellis that the right to life, within the terms of its domestic statutory expression in Section 8 of the New Zealand Bora, impliedly gives rise to a positive duty to investigate, despite the absence of the words that the right to life shall be protected by law. The court said there is in Section 8 an implied right to have an ICCPR compliant investigation into potentially unlawful deaths for which the state may be held accountable. The rights exist as a necessary incident of the right to life affirmed in Section 8. Coroner's investigations which must happen where life has been lost at the hands of a police officer acting in the course of duty should ordinarily meet the state's investigative obligation. The court added, whether any given death has been effectively investigated seems to us a mixed question of law and fact, which must be answered in context. The Court of Appeal also upheld the decision of Justice Ellis in identifying the content of the duty to investigate, that is, what human rights standards should apply. Justice Ellis held that the obligation to investigate does not require a particular kind of investigation, but one that is adapted to the particular circumstances. What is required is a matter of substance and not form. She accepted that the requirement for a rights-compliant investigation can be fulfilled through a combination of different inquiry processes, as the fact-finding and accountability components of the investigation obligation may be shared between authorities, including coronial and criminal authorities, provided they are procedurally effective in totality. Relying on Jordan and the United Kingdom, Her Honour pointed to the need for a rights-compliant investigation to be independent, effective, reasonably prompt, have a sufficient element of public scrutiny, and in all cases involve the next of kin to the extent necessary to safeguard their legitimate interests. Well, what do those requirements mean? Independence requires a separation and a practical independence from those implicated in the events under investigation, including an absence of any hierarchical or institutional connection. Inherently, investigations and inquests by coroners clearly satisfy this requirement, the coronial system being institutionally established as an independent body. Effectiveness means that the investigation must be capable of leading to a determination of whether any force used was or was not justified in the circumstances. Any deficiency in the investigation which undermines its ability to establish the cause of death or the person or persons responsible will risk falling foul of the standard. The investigation need not deliver those outcomes, but it should be a means of achieving them. As the House of Lords observed in Middleton and West Somerset Coroner, omitting to make a finding on a major issue may both fail to meet the expectations of the next of kin and risk failing to identify systemic failure to protect human life, and that would be inconsistent with the objects of the Convention. Promptness not only requires that the investigation be undertaken with reasonable expedition and carried out with reasonable speed, but also that it be initiated by the state and not dependent upon the initiative of the next of kin. Accountability means that both the investigation and its results should be subject to public scrutiny in a practical way. The requirement for the involvement of the next of kin is important. Investigations have been vitiated as inadequate, where the parents of a deceased could only attend when giving evidence, were not represented, were unable to put any questions to witnesses, and had to wait until the final version of an inquiry report to discover the substance of the evidence of what had occurred. It was held that the procedure adopted did not involve the parents to the extent necessary to safeguard their interests. Her Honour recognised that an inquest, which is open, independent, transparent, and takes place with family involvement, is likely to be the appropriate vehicle for a rights-compliant inquiry of this kind, particularly by comparison with investigations by police agencies. However, she was aware that an inquest may not always satisfy the criteria. She applied each of the requirements of Section 8 to the multiple inquiries that investigated the death of Stephen Wallace. She found that they did not individually nor collectively discharge the state's investigative obligation under the New Zealand BORA. She held that in the ordinary course, a criminal trial is an effective procedure for finding relevant facts and attributing criminal responsibility, and if relevant, can be relied upon in subsequent inquiries, including those by a coroner. However, she considered that a private prosecution was not capable of discharging the investigative duty because the obligation to investigate rests on the Crown, not the family of the person who has been killed. This meant that in the circumstances of the case, the later inquiries that relied on the findings in the private prosecution could be tainted and ineffective. Specifically focusing upon the inquest, Her Honour held that it was independent, accountable, and had appropriate involvement by the family. As for promptness, the inquest was adjourned pending the private prosecution, and when it resumed, it was necessarily delayed by an unsuccessful application for judicial review. The critical issue was whether the inquest met the requirement that it be effective. Her Honour held that the inquest was ineffective for one reason only, namely that the coroner did not inquire into whether the level of force was justified. Rather, the coroner treated the jury's verdict in the private prosecution as having conclusively established self-defence, despite the fact that the criminal trial in the case was not adequate, in her view, to meet the Section 8 investigative obligation. As it happened, she went on to determine for herself, on the evidence available, that the killing had occurred in self-defence. On appeal, the Court of Appeal held, contrary to Justice Ellis, that a private prosecution is capable of meeting the state's obligation to investigate a deprivation of life and establish whether it was justified. This is because, as the Court of Appeal commented, although the state did not initiate the prosecution, the proceeding rested almost entirely on infrastructure provided by the state. Depositions were held, an indictment was presented, a judge was assigned and a jury impanelled to treat the case, Constable Abbott was arraigned, witnesses were compelled, the trial was designed to establish and did establish what happened and whether Constable Abbott was criminally liable for it. If found guilty, he would have been sentenced. All of this was done by the state at the instance of the private prosecutor. The Court of Appeal thus reversed Justice Ellis on this point, holding that the inquest satisfied the criteria that it be effective. The coroner was entitled to treat the private prosecution as equivalent to a criminal trial, including the findings arrived at on self-defence. Well, as I've discussed, the Court of Appeal otherwise upheld the view that an implied obligation to investigate arises under Section 8 of the New Zealand BORA, despite the way the right has been formulated, and endorsed the human rights standards that a Section 8 investigation has to meet. Overall, the Court of Appeal upheld the inquest as rights compliant. In 2023, the New Zealand Supreme Court dismissed an application for leave to appeal. Well, to make a final point, I think we can agree from an examination of the New Zealand case of Wallace and the background of international law that in the Australian jurisdictions that have specific human rights legislation, there is much yet to be explored about the scope and importance of the right to life. Thank you.